Employees and licensees are responsible for illegal activity on their premises. Chronic illegal activity includes a pervasive pattern of activity that threatens public safety of the local government's jurisdiction. The activity may include open container violations, assaults, disturbances, disorderly conduct, or activity documented in crime statistics, police reports, emergency medical responses, calls for service, and similar records. Chronic illegal activity is also an unreasonably high number of DUI violations. This also includes your parking lot and sidewalks surrounding your establishment. When a liquor license is approved, a certain amount of the property surrounding your establishment is your responsibility. Hours of legal alcohol sales and service. You can legally sell and serve alcohol from the hours of 6 a.m. to 2 a.m. By 2 a.m., all alcohol has got to be removed from your guests. All tabs that are open have to be closed out as well. If you work in a tavern that sells beer or wine to go, then the beer or wine has to be removed from the premises by 2 a.m. This also includes your posted hours. If you close at 10 p.m., your alcohol sales and service stops at 10 p.m. Here's an example. A guest comes in at 9:45 and orders a burger and a beer. It is now after 10 p.m. and they would like another beer. They cannot get one. However, they do have legally until 2 a.m. to finish the first one. Once you are closed, no one can be served alcohol. This includes employees having drinks after you're closed, such as a glass of wine while you're doing your books or having a drink with the staff after closing. Your liquor license is considered to be a public license. To be able to serve alcohol, you have to be open to anyone from the public to come in and have a drink. If you work in a private club, then you have to be open to all members. Exchange the word public with members. Employees and licensees cannot ever be intoxicated on their own premises. In fact, you couldn't get intoxicated up the street and stop by to say hello. You can have a drink where you work at, you just cannot become intoxicated. Food service. Food must be available at all times alcohol is served. Beer and wine taverns, private clubs, and establishments that operate under the nightclub license do not have to have food. Everybody else has to have food. Beer and wine restaurants have to have their whole menu available at all times and be open for a minimum of 5 hours concurrently per day. If an establishment has a lounge or is licensed with the 11 p.m. rule, the establishment may go to a limited menu. Chips, nuts, etc. are not considered food. For a spirits, beer, wine license to serve alcohol, they have to have the food available at all times for 5 days a week, 5 hours concurrently a day between the hours of 8 a.m. and 11 p.m. A minimum of 8 different separate entree items have to be available. An entree is a main course with a side that has to be eaten with food implements. Outside of those hours, a minimum menu can be in place with the hours of food service displayed in a visible place. Corking wine. In the state of Washington, if your guest does not finish their bottle of wine, they may take it home with them. Only if they're in a restaurant, not a premise licensed area such as a lounge or a tavern. No open container with alcohol can be taken off such premise. After you have corked the bottle, put it in a bag. You don't have to do this, but it's nice to do for your guests, and ask that it be placed in the trunk of their car. If they do not have a car, ask them to place it to where it can't be reached. Otherwise, it could be considered an open container. This actually goes one step further. In order for them to take the wine home with them, they have to have consumed a meal on your premises. They couldn't order just a bottle of wine, drink part of it, and take the unfinished contents with them. This also includes ordering food to go and adding a bottle of wine to the order, unless the establishment has a license that permits them to sell unopened bottles of wine for off-premise consumption. It is illegal to open a bottle of wine for your guests, pour them a sip, and then they take the open bottle for off-premise consumption. Because of the legalities of this, here's what we suggest you do. When a guest requests that they desire to take the unconsumed wine with them, mark the wine level on the bottle, date it, initial it, bag it, and staple the bag closed with a copy of the receipt showing the food they had with the wine. In the state of Washington, it is legal for your guests to bring in their own wine. In order for them to do so, they have to consume a meal on the premises at the time the wine is consumed. It is illegal to sell or serve hard alcohol by the pitcher, fishbowl, or a container meant to share with others. Spirits cannot be sold by the bottle. They have to be sold by the drink, unless your establishment operates under a hotel or private club license. Either one of those are considered to be an extension of your home. A guest may purchase an unopened bottle of spirits to be consumed in the hotel room they have rented. A private club may allow members to bring in their own spirits and consume it. But be very careful of this, as overservice can happen. The Washington State Liquor Control Board has the right to inspect a licensed premise or when a banquet permit has been acquired at any time deemed necessary. They have the right to examine books and records as well as to take samples of liquor for analysis. No advertising, bottomless drinks, etc. Advertising cannot be used to promote overconsumption or promote advertising that appears to show minors consuming alcohol. If you're a beer and wine restaurant and use hard alcohol to cook with, the container the alcohol is in must be marked as for cooking only. No hard alcohol is allowed on a premise licensed for beer, wine only. Banquet permits. An establishment that has a banquet room or chooses to rent their establishment for a private party can allow the persons renting to obtain a banquet permit to serve alcohol. The alcohol beverages cannot be provided by the establishment unless it is purchased in advance from the establishment at retail, and it cannot be sold to the guests who attend the event. Alcohol cannot be removed from the premises unless the establishment has a caterer's endorsement. Alcohol cannot be shared with establishments owned by the same group. Each premise has its own license. Required signs. No minor signs have to be posted at all entrances to the restricted area, either the front door or the entrance to the lounge. No firearm signs have to be posted in a conspicuous place in the lounge for all to see. Their master business license with liquor endorsements has to be posted in a conspicuous place for all to see. If you sell tobacco, the tobacco sign must be posted at the point of sale of the tobacco. Pregnancy signs must be posted at the entrance nearest to where alcohol is served or sold, as well as all women's bathrooms. Wineries, breweries must post the pregnancy sign at the main entrance and entrance to the areas where alcohol is sold, and women's restrooms as well. If you violate any liquor law, such as if you were to get a DUI from this day forward, your mass permit might become suspended. If you serve a minor, your mass permit might become suspended. If you were to get a controlled substance conviction or a felony conviction, your mass permit might be suspended. Now, what happens if you get a violation from the Washington State Liquor Control Board? This charge can either be an administrative violation, an ABN, or it could be a criminal violation. The difference is this: an ABN is a severe reprimand with a fine that will come off your record, and whereas a criminal violation, it can be on your record forever. Also, the city police and county sheriff can cite you as well, and they don't have ABNs, they have misdemeanor criminal charges. What laws are we talking about? There are groups 1, 2, 3, and 4. Group 1 is the most severe as it deals with public safety. Group 2, conduct violations. Violations involving the conduct of retail or non-retail licensee employees or patrons. Group 3, regulatory violations. Violations involving administrative requirements. And Group 4, general violations. Violations involving the manufacture, supply, and/or distribution of liquor by non-retail licensee and a retail license.